That's right. Court does call the case of the people versus James Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Benn, and I'm hearing with and on behalf.
Here we go, people. V. James Whitley. The courtroom tension is already. And if you think this is going to be a routine hearing, think again. The way this judge reacts set the tone for everything that.
James Dennis Whitley.
This is people's emergency motion to modify violence in this case.
I find it surprising that.
Did you catch that the prosecution is claiming danger, but the supposed key witness didn't even bother to show up? That's like calling the fire department. When no smoke, it raises the question. How strong is the case?
They're alleging that she's in danger, the prosecutor, and they don't call her to show up. She reached out to a friend of my client.
Call her to show up to do what?
Today to say I'm afraid. I mean, I will say,
Mr. Bennett, you've been doing this long enough. You know that's not going to.
And boom, the judge just snapped. This is what I mean when I say courtroom etiquette matters. Accusing a court of favoritism is one of the fastest ways to light a fuse. Judges see that as a direct attack on their integrity. And when that happens,
I don't know, at 3 o'clock with 24 hours notice, I couldn't have got a hearing in that.
Could have got a hearing on what?
If this was reversed.
Absolutely. Oh, do not even insult this court by saying that, Mr. Bennett. Do not, because you would have gotten a hearing. Had you filed a motion, had you requested that it is an emergency hearing, the public defender's office does it all the time. The fact you don't know how to do that and think that this court is playing favorites, you're wrong. Court's going to stand in recess.
Right. Have you seen it? 14A District Court for County, Washington. Session, the Honorable Judge J. Sedgwick.
You may be seated.
wow, 25 years on the bench, and the judge says she's never insulted this badly. That's not just a rebuke. That's history being made in real time. Let me throw this back at you. You think there should go all out, even if it risks.
Court recalls the case of the people versus Whitley.
Good afternoon, Your Honor. For the record, my name is Jeffrey Benn. I'm hearing with and on behalf of Mr. Whitley standing to my right. Can you state your name before, please? James Dennis Whitley.
Let me just say this, Mr. Bennett. I've been on this bench almost 25 years, and never have I ever been insulted in the fashion you just insulted this court. No, my turn. The case, the very first case, when you say that defense counsel or anybody else doesn't get access to the court like the prosecutors.
Here's something important. Judges actually have the authority to change a bond ruling without a hearing. Think about that. But in this case, the judge, didn't she make an effort to hold a fair hearing instead? That tells you.
You are absolutely wrong. The first case I called today was upon receiving a notification about something that I had considered in a bond, was notified that that had been located. This court, to the defendant's benefit, set that hearing without notice to any side. I set the hearing. So to be fair to all of the parties, I receive motions all the time regarding bond. And this court just seeks to be fair, to have a hearing.
And this is the final word. Even though the judge is angry at the attorney, she makes one thing crystal clear: the client won't be punished for their lawyer's misstep. That's judicial discipline action. And it's a reminder that, at the end of the day, justice is supposed to focus on the defense.
Mr. Bennett, if I had in my heart the desire just to lock your client up, quite frankly, because the decision came from a magistrate under the court rule without a hearing, I could have changed that bond. But I wanted to give the parties the opportunity to be heard. Now, having said that, So maybe you can put that in a little perspective. I heard you that you said you just got the discovery, can't go through it. Well, I'm going to give you about another 18 hours to go through it because I'm adjourning this hearing for two reasons. To allow you to go through the discovery, to give me a cogent argument as to why I should not grant what the people want. And secondly, because you have raised the ire of this court. I am not going to punish your client by what was one of the most ignorant statements I have heard about the conduct of this court from any counsel in all of my years. I will not, by any means, punish him for that. I do not make my decisions out of anger. I'm adjourning this to tomorrow, May 10th, noon. All the parties are ordered to be here. That is all.
Your Honor.
That is all. Noon tomorrow. All right. They're bringing him.